USPTO trademark process. How does it work? In this video, we're talking about 1B or intent to use applications. These are applications that you file because you want to have your trademark registered, but your goods and services are not in use in commerce yet. Remember, you have to have your goods and services in commerce before your trademark will be registered, but you still file the application before the specimens are ready. Today, we'll follow a 1B or intent to use application and what the process is. Go to the USPTO.gov website, click on this trademark tab, and it's going to take you to timeline to process an application. We'll go look down here. 1A we did in another video, which is your services are good. 1A we did in a different video. This is where your services and goods are currently in use in commerce, and you file the trademark application that way. Here we're going to click on this. What this means is that it's not in use yet, but you plan on having it in use in commerce soon, but you want to protect it and start the process earlier. Let's start with that. So remember, everything in red is what you do. Everything in blue is what the USPTO does. So you file your application. They're going to tell you it's going to take about 8 months right now. So here is the current time frame right now. They're reviewing things from last September. Right now, it's May 28th. So it's about 8 months, a little bit less than 8 months. So this is the current wait time that we're looking at here. USPTO will review the application, and then they'll take one of two actions. They'll either approve the trademark application and publish it for opposition, or they'll issue an office action. Let's say they approve it. What they'll do is go down to publication. Assuming no one has filed an opposition to the trademark registration, they'll issue a notice of allowance. This is when they say, okay, everything in this whole process is good. We just need to see proof of use. Here, you see all the red things that you need to do in order to take the next steps. You can either file an extension saying we're not ready, we need another 6 months before our specimens are ready, or you file a statement of use which is saying these specimens are currently in use right now. Here's my declaration and the documents and the proof that they are currently in use in commerce. Or you don't do any of that, which in that case, if you don't file anything timely, your application will abandon. And so you could revive it, but it costs you money to revive it. But let's say you do file an extension. You can have up to 5 extensions of 6 months each. So once the notice of allowance, as soon as that starts, you have approximately 3 years if you file 5 extensions to provide your statement of use. But if you do, let's say you run out of extensions, what do? Well, you don't have any more options at that point. Unfortunately, if you don't file a statement of use by the end of that period, your application will abandon. You will have to file a new trademark application, and you can file a new trademark application. Let's say you do file a timely statement of use. USPTO will review it. You remember everything in blue they will do. They will either approve the statement of use, or they'll issue an office action saying this does not comply, or the specimens does not match the drawings. And if it's approved, then your application will be registered, and this goes on to filing the Section 8 at the 5th-year mark and Section 8 and 9 at the 10-year mark. Let's say you do file the application and it doesn't go quite well, and the USPTO issues you an office action. Then you have 2 options. You can either submit a response, timely response. If it's approved, everything's resolved, then it moves on to publication for opposition. Assuming nobody opposes it, then it goes on to the notice of allowance and follows that loop. If they issue you a final office action, you can either respond to the final office action and or file an appeal to the TTAB, Trademark Trials and Appeals Board, or if you do not fix it, then the application will be abandoned. All right, let's say you do file the TTAB appeal. TTAB will review it, either confirm the refusal, maintain the refusal, or reverse it. That is, in a nutshell, the 1B application. Again, as I mentioned previously, this nutshell is not so small, but you can go follow the same path and hover over these different elements, and the USPTO will tell you a little bit more detail what's required of each step. For more trademark tips and tricks and news, please visit tmtelegram.com. And until next time, keep your brand safe and protected. Have a great day. Bye-bye.